illegal, null, and unconstitutional. And then the court has ordered that both should vacate the office, including other lawmakers who also defected with the governor and his deputy to the APC. But the governor has said he is going nowhere, saying everything that the court has done is illegal and has no constitutional backing. So this morning we'll be looking at what this is all about, this court ruling, and then we'll be looking at the implications, legal and political, as it were. We have two gentlemen who will be helping us to analyze some of these issues. Nkem Okoro is a lawyer. He is seated right here in the studio. We also have Tochukwu Ahazurike, a lawyer, in the studio as well. Joining us via telephone will be the Commissioner of Information, Ebonyi State, who also happens to be a lawyer. So these men, for balancing, will be giving us a political and legal perspective to all of this. Thank you, gentlemen, for being on the show.
All right, let's begin with the legal conversation first. I know that this festival is about the rule of law, Tochukwu, let's look at it. Tochukwu, I want to start with you. Okay. I don't know if you listened to the newspaper review, and most of the reviewers, what they said was that, well, the court takes jurisdiction in this kind of thing, and then respecting the rule of law is the most important thing before the political conversation. What do you make of this case right now?
Thank you so very much. Before I discuss anything about this matter, or indeed before any lawyer discusses what happened yesterday at the Federal High Court, Abuja, I think the first thing, the first duty that lawyer owes the judiciary is to reprimand, maybe in very deliberately selected words, the conduct of the governor of Ebonyi State yesterday in addressing my Lord Justice Inyang Eko in very unprintable words. Okay. You know, he called a press conference where he severally called the judge a hatchet man. You know, and
that he was paid.
Said a lot of things that shouldn't have been said. Personally, I've been involved in cases where I got judgment against me, or even where in a case I'm not involved, but I felt justice should have been the other way, but it turned out the other way, and I expressed my grievances with that. But it wouldn't move me to use such unprintable words against a governor, against a judge, because tomorrow, when the judiciary gives a judgment in his favor, he is the one that will come out again to shout, oh, the judiciary is the last hope of the common man. You can express your grievances, but you must do that maturely, you must do that responsibly, not just the way he did it. And if Nigerians know the details of what that governor did to stop this judgment from coming, very illegal and fraudulent things the governor did and masterminded. Now, what did he do? The governor, this matter was filed sometime in August last year. The governor was a party, his deputy was a party, the APC, INEC, they were all parties. Parties filed their processes. Hearing was concluded sometime in January 2022. Judgment fixed for March 8th. January 2022 was the final day for hearing. The court adjourned for judgment. February 4. February now, the month after the hearing, the man who is now a party member of the governor filed a suit quickly in the Ebonyi State High Court, taking himself, the man who was his deputy candidate, governorship candidate then, and the APC. They now purportedly filed a suit against the governor and his deputy, without joining the PDP that they had a case here with, without joining INEC. What did they do? Between February 4 and February 28th, a judgment was given. Now, somebody could say, oh, but yes, it could have been that fast. Now, let me tell Nigerians to note that when the matter that was filed, the governor's brother was his lawyer, allowed. But why wouldn't Nigerians worry that a lawyer in the private firm of the Attorney General of Ebonyi State was the one that took them to court? To tell you that they sat on a table like this, and said, okay, you will file, you will join this one, and then this one will defend me. And because the Attorney General now supplied a lawyer who went to court against the governor. and they arranged it, and within 23 days, they had a judgment delivered. And that is the judgment he rushed to this court with. Started shouting to high heavens that, oh, I started writing to everybody, the CJN, the NJC, that there is a pending judgment. And Justice Inyang wanted to...
So it seems like he's the one that did the hatchet
job. He was the one that did the hatchet job, if there was any hatchet job. He indeed was the one that did it. So for him now, after doing something like that, to come out... See, it is for lawyers who practice in Abuja who know Justice Inyang. He is a judge that is bold. He's a judge that is not afraid to say it the way he feels it is, and the way he feels it is the way the law tells him to feel it is. And he says it like that and he walks away. Many of his controversial judgments, when they come, people shout both sides. But when they go upstairs, the court will almost always say, but that thing he said is correct. He was the one, if Nigerians have forgotten, that that gave the judgment in the Bayelsa governorship case about the name of the deputy governor of Bayelsa, governor-elect of Bayelsa then. He was the one that gave that judgment. People shouted, oh, said all sorts of things. What is in the name? After all, nobody has come to claim the name. The Supreme Court found merit in what he said. Very recently, he gave a judgment against an unmarried police officer who got pregnant. A case taken up by the MPA. He gave a judgment and said, no, the woman was aware of the rules of the police before she joined. So if you know the rules and you go and break, don't come and tell us. So the man is a man that does judicial activism. He does research. To move a motion before Justice Inyang, if you're not prepared, he will not grant your expertise.
All right. Let me come from this angle. Now, here is the issue. Just last month, the Guzo Division of the Federal High Court ratified the defection of the governor of Zamfara State, Bello Matawalle. And we do know that Matawalle also dumped the PDP and moved to the APC. Now, the worry for many people is, isn't this a contradiction from, or is it not the same case? Why is there a sharp contrast in these two judgments?
All right, okay. Let me just take a sharp shot at it then. My colleague will take over. Just like the judgment I mentioned now in Ebonyi State High Court, the PDP that had interest, whose interest was to be determined, was not in that matter. So somebody will say, oh, is this judgment not contradicting the one in Ebonyi State? The question is, who are the parties that were in Zamfara? Did the court hear all the parties? A judge, ordinarily, if you look at the affidavit in Ebonyi State High Court, that affidavit contained PDP as a party who had throughout the body of the affidavit in support of the originating summons. PDP was reflected everywhere. In the written address, it was all about PDP, moving from PDP to AP. And the judge did not deem it necessary to say, sorry, this PDP you are calling, who is this PDP? Can I even hear from this PDP? And the judge did not. The judge has a right to say, no, I think to give justice, the justice of this matter can be determined if I hear all the relevant parties. And from your affidavit, PDP seems to me as a relevant party. That order was not made. But the hatchet job was quickly done so as to... So I don't know what happened. I don't know the details of what happened in Zamfara State. But when the details come out, you will not be surprised to note that there are issues fundamental that must have denied a party that is right necessary hearing in that matter. So it's as simple as that. So it's not contradictory. What a judge does, moreover, is to look at the body of evidence before him and he gives his judgment. And note also that the High Court judgment of a court or the judgment of a court of coordinate jurisdiction only is persuasive on a judge. He's not bound to follow it. He can distinguish. He can even say, oh, based on the differences, look at what happened.
All right.
So those are the issues.
Let's first, before I come to you, Bryce Nkem, let's go to the phone where Commissioner Ojuche Naoje, Commissioner for Information for Ebonyi, is waiting to speak to us. You heard from Tochukwu that it seems that it is the governor who actually did the hatchet job and not the judiciary, where he also masterminded proceedings to his own case and was using that as brevity to be able to usurp justice. What do you have to say about that?
Thank you very much. I've listened to my colleague, Mr. Tochukwu, and I want to say that I've got no need to join issues with issues of motives, sentimental issues that he raised. He has not addressed any point of law. Even when you ask the issue of the judgment of Zamfara, he also did not address the issue, so I'm not going to join issues with him. because I've not seen a substance that he did raise. Now, having said that, now the issue of obedience to the rule of law, which you did mention, I can tell you that the state government, and indeed our governor, is known for obedience for the rule of law. But the crux of the matter is that a court of competent jurisdiction that has coordinated jurisdiction or powers with the Federal High Court did give a judgment in the same matter, the same subject. What is the subject? The subject matter is whether or not defection can avail a court the powers to declare that the governor or deputy should vacate office. And the court said no, that defection has got no offense under the Constitution. And they came by originating someone, that is, to interpret the construction of the external laws and the Constitution. And that was what the judge did. And now coupled with the Federal High Court judgment in Zamfara. Now, given what happened yesterday in what I call equal judgment, like the Ebo judgment, the governor said, we have a substituting judgment on this. And so I'm going to obey that judgment. I cannot obey this judgment that is inconsistent with the judgment of a court of coordinated jurisdiction on the same matter, the same subject matter. And that is the issue. However, we are going to study in details the judgment so that for the sake of posterity, we will put the record straight. And that is to say, we will be going an appeal. But that does not in any way mean that the governor has vacated office or shall vacate office. Because even the rule of the court, Federal High Court, says that he has within 90 days. That is to say, he has the powers under the Constitution to exercise his appellant rights, even up to the court of up to the Supreme Court. Then, having said that, let me mention that legal luminaries have even joined forces to say that the judge, learned judge of the Federal High Court, Ebo Inyang, erred in law for not relying on any provision of the Constitution, for not relying on any provision of the Electoral Act. By the way, there is no provision in the Electoral Act from Section 1 to Section 153 that has got anything to do with the governor after he has been sworn in. It is only the Constitution of Nigeria in Section 143 and Section 144. And there are only three conditions for the removal of a governor or deputy under the Constitution. One is on account of death, one is on account of resignation, and one is on account of impeachment by the legislature as contained in 143, 144. Nothing more, nothing less. And so going to raise issues of pre-election matter or election matter in the case of Amechi and INEC, the mayor case. The Supreme Court, even in the case of AG Federation and two others, and Alhaji Atiku Abubakar and three others, reported in 2007, has really settled the matter that you cannot, for any reason of defection, remove or sack a vice president, and that is applicable to president, applicable to governor and deputy governor. And even in that same case, they said that it is against the fundamental right of freedom of association of the governor, deputy governor, president, or vice president. I know the issue of freedom of association is fundamental. Is the supreme provision that cannot be violated by anybody whatsoever. And so that is what we should be addressing. And let me assure you that the people of Ebonyi State are in full support of the governor. What you saw on the first page of or front page of some newspaper is the rental crowd. You're going to see the movement of Ebonyi people in this regard. But we aren't people that are not law-abiding, but we must express our feelings over all of these aberrations. Do you know legal luminaries like Oyekeme, Zekeme said that this is a legal aberration. That unless the man doesn't want it to be tested, that it cannot survive the furnace, the test of the appellate courts. And that is the position of the law.
All right, Honorable Commissioner, sir, we understand that, you know, you have issues with the judgment, which it is also your right, and you also have the right of appeal to even up to the Supreme Court. But I've listened to lawyers who argue that if a judgment is given by any judge, irrespective of who the judge is or whether it is in your favor or not, that the first thing you should do is to obey the law first, and then you can go on appeal. This is on the law angle, and I'm asking you this because you are also a lawyer. So, to obey the rule of law, are you not expected to obey that law first before you go on appeal? That is one. Then, quoting the judge did say that the votes in any election in Nigeria are to political parties and not the candidates. You are also a politician. So, from that angle too, if the governor stood for election on the platform of the People's Democratic Party, only to dump the party on whose platform it rose to power, he rose to power, and on whose mandate and even manifesto he promised the people development, and then goes to another party with a different manifesto entirely. What does that say about the person of the governor and, of course, the activities he has been carrying out in the state since the defection?
Thank you very much. Let me say that if there are two subsisting judgments by the same court, that is court of coordinate jurisdiction, on the same issue, the same decision, or rather different decisions on the same issue. Now, which one will you obey? That will be my question to you. And you must obey one at the same time. So I want you to answer that question. We have chosen to obey the one that we know that complies with the decision of the Supreme Court, the one that we know that has complied with the most recent decision of the Federal High Court. And so we cannot obey two judgments at the same time. So if you want us to obey two judgments, tell us how we can do that. That is by the way. Now, on this issue of defection, the rule of law means the rule of the pronouncement of court of competent jurisdiction that is based on the provisions of the law and constitution. That is what rule of law is all about. And now, the constitution has said that we have not seen anything wrong in defection. Defection means to move from one party to the other. Now, the reason is that it does offend the most supreme and the most sacrosanct provision of the Constitution, and that is the issue of fundamental human rights. That is the jurisprudence of it. And so, if the Constitution or the law, as it were, has not, made defection a crime or a breach of the rule, then why will you go to invoke that? Oh. And so, the issue of manifesto, and let me tell you one thing, under a presidential system of government, the president, the governor, is responsible for the actions of government. And so you may decide to work with a manifesto that you think at a material time that will work in the interest of your people. Because if you don't do well, you'll be blamed. If you do well, you will be praised. And so the chief executives under the presidential system of government, are entitled to do those things that will bring about development, bring about progress in their place. So manifesto or no manifesto cannot be the issue.
Okay, let me quickly ask you this. Sorry, Adora. Let me quickly ask you this before we come back to the studio. If this judgment of Inyang Ekwo was to be in your favor, would you have obeyed it?
Yeah, if it was in our favor, would have been a confirmation of the decision of his brother judge. Don't forget the judge of the State High Court that gave judgment is a senior.
right.
A senior, much more a senior to him. And the powers of the State High Court is the same thing with the powers of the Federal High Court in respect of this issue. And so we have chosen to obey that of the State High Court, who himself, the judge himself, is even much more senior in bench than Ebo. And don't forget, we have heard a lot of interim injunctions by this Ebo. I just hope that it will not eventually be like Ebo kind of a situation. It is really unfortunate. And you can see that people are criticizing the judgment. That is an aberration. Like there's no contention with the provisions of the law and the Constitution as it were.
All right, thank you. Thank you, Honorable Commissioner. Let's come back here to the studio. Barrister Nkem, you've heard what the conversation has been like. I mean, there's a show of precedence, case, and outcome. The Honorable Commissioner has given rise and alluded to sections 180, 188, and 189 of the Constitution. And one of the things he's saying that is that when we look at the precedents set by some of those judgments, for instance, the case of the Attorney General of the Federation versus Atiku Abubakar in 2007, in the case where he had a running battle with his first man, President Chief Olusegun Obasanjo. But coming back to what he has said, according to the law, you are a lawyer, and I'm sure you've heard what Tochukwu has said and what the Honorable Commissioner has said. What do you think is the set standard for vacation of a governor from office alongside with his deputy, who, even though he has run under a different party and has defected? What does the law give credence to?
I'll start from the viewpoint that what was an issue in the case before Justice I.E. Eko was the rise of the political party. Unlike the case of Attorney General versus Atiku Abubakar, where the facts of the Attorney General's case and Atiku Abubakar are not the same facts. In fact, judges are bound by the ratio in a case where the facts and circumstances are similar. In this very case, what we are looking at is the rise of the political party over the public right of the governor. You know, and the law is that private rights, the private right of the political party overrides the public rights of the governor. So what we are looking in this very scenario is the judgment of the Federal High Court delivered yesterday by Honorable Justice Eko. Was it in tandem with the provisions of the law? And I will say yes. Section 221 of the Constitution provides that it's only political parties that can contest elections in Nigeria. Section 177C of the Constitution provides the qualification of a person to contest for election as a governor in Nigeria. And one of those qualifications is that he must be a member of a political party. Now, prior to this time, there has not been any decision with respect to defection of a sitting governor. Justice I.E. Eko should be applauded for his judicial activism. No decision has ever been given in Nigeria on the issue of defection of a sitting governor. So it was a novel case, which the judge researched, which the lawyers in the case researched, and submitted the authorities, the basis of which the court gave its decision. Now, the political parties in Nigeria have vested rights by virtue of Section 221 of the Constitution and Section 177C of the Constitution over the seat of a governor. Also, when you look at the various Supreme Court decisions where it is held that votes garnered by an individual in an election belongs to a political party, what happens to the political party where the individual suddenly abandons that political party? What we are looking at is not the rights of the governor. We are not looking at the rights of the governor. We are looking at the constitutional rights of a political party. If a political party has a right as enshrined in the Constitution, then if that right is infringed upon, is breached, do they have any remedy? And by Section 66B of the Constitution, the courts have jurisdiction to entertain any question of law as it relates to the rights, civil rights and obligations of parties before it. So political parties in Nigeria, they have rights over the candidate who they nominated and sponsored for election.
Okay, let's look at the case again, bringing in the Zamfara State governor. And we remember that on June 11, the governor, defected to another party. There was also a law, you know, that there was a court case in that regard. Yes. And with immediate effect, the party said, let the deputy governor who remained, you know, take over the party seat in the state. And we saw what happened when the Nigerian police set in. There was, you know, a lot of dust raised on that. Yes. Now, why is that an exception? Can you tell us exactly what happened in the case of the Zamfara state governor as vis-a-vis what is happening in Ebonyi state?
Well, the facts of every case, judgments are determined or delivered on the peculiar facts and circumstances of each case. And you cannot, because maybe there is a judgment of the Federal High Court in respect of the Zamfara matter, Justice Ekpo, Federal High Courts are all courts of coordinate jurisdiction. And before a court of coordinate jurisdiction is not bound by the judgment of the brother judge in respect of the same issue. It is only the appellate courts that the lower courts are bound by their judgments. So Justice Ekpo, whether the issues as relates to the case in Zamfara was brought to his knowledge or in that matter is a different thing altogether.
Why? Why? Because it raises conflict of understanding for different parties.
No, ma. The point is, these are courts of coordinate jurisdiction. The facts and circumstances under which the decision in Zamfara was given may not have been the facts and circumstances, the laws, the legal issues canvassed in the case of Zamfara may also not be the same legal issues canvassed in the case decided by Justice
But there's something that has been established, the fact of defection from one party to the other.
Yes.
And funny enough, both of them defected from the same political party to the same political party.
Yes.
So that is where the issue is. If they are both court of coordinate jurisdiction, one cannot rule over the other.
And the other then.
Okay? So that is where the confusion is coming from. And then the issue of the Constitution you're also quoting, the Constitution also stipulated the methods by which a sitting governor can be removed from office. So is there a contradiction really with what the rulings we are getting from the High Court and the Constitution itself? Is there, I don't know, how would you describe this? You are a lawyer.
Okay, yes. I want to state, yes, that the Constitution made provisions on how a governor can be removed. That's the process of the removal of a governor by the House of Assembly.
And the court is not one of them.
I'm coming, ma'am. You understand? Now, there is what we call setting judicial precedent. We have a novel issue that has never arisen in Nigeria. No court in Nigeria has ever given decision with respect to defection of a sitting governor and the governor losing his seat as a result of the said defection. So what we had in the case of Justice Ekpo was a very novel issue bordering on the defection and the rise of political parties over their candidates whom they sponsored. Are the political parties supposed to go empty-handed, given that they are the owners of the votes by which? So what Justice Ekpo did was just to confirm the position of the law that has been set long before now.
All right, so where does this leave us, Tochukwu, in the whole argument? Because it will seem like there's a bit of confusion about all of it.
No, absolutely, there's no confusion. Now, let's piece them together so that it will be clear that there's no confusion. Let me go to Ebonyi State High Court. Ebonyi State High Court wanted to determine whether a governor who has defected should lose his seat or not. Now, the person that took him to court was the person who was the APC candidate in the last election. Now, who now purportedly says to the court, because he has now left the party, let him leave the seat for me. Because by leaving his party, he has lost the seat. Now, that should have been the argument, right? That an adverse party, properly so-called, should have held. But now they are colleagues, they are friends, they are political allies now in the same political party. Now, you did not join that adverse party. The issue of Justice Ekpo. In Justice Ekpo's case, PDP went to court and said, court, what is our right? Do we have any rights? In Ebonyi, the question of the right of PDP that lost the governorship seat that they won was not the issue before that court. So the court determined a different issue. In Justice Ekpo's court, the court determined the right of PDP. except the court says, oh, PDP, you don't have any rights here, you don't have anything to lose or anything. That would have been, but the court says, I think PDP has a right. You sponsored a candidate, you scored votes. The votes do not reside with the candidate, but with the political party. Nigerians will remember the Kogi State issue, where Abubakar Audu of blessed memory scored votes. Yahya Bello inherited the votes of the dead man. He inherited the votes because the votes belonged to the APC. So if they bring another candidate in this time, Yahya Bello, it happened. Remember in the Imo North senatorial election, I declared APC winner. Because as at that time, there was an issue about who was the candidate of the party. APC owned the votes. So the rule was that, okay, APC has won. When the issue of who their candidate is settled, the candidate will inherit those votes. Just recently, February 12, just last month, Abaji, area council election, there was an issue about who was the candidate of APC. The votes were declared. The results was declared. APC was declared winner without a candidate. Just last month here. The votes reside with the party, not the candidate, because if they had no candidate as at that time, and they could not have declared them. So at that point, even APC accepts that the vote is our vote, not the candidate vote. Hey, don't worry. You remember there was a time PDP was using that tactics to win election in Anambra. Deliberately, they will field 2 candidates. This one will be mobilizing from this axis. The other one will be mobilizing from the other axis. When the election is over and PDP is declared winner, they now go and sort out who will inherit the votes of the party. So both parties have done it. So there is an acceptance for politicians that the votes reside with the political party, not the candidate.
The judiciary too.
The judiciary has also recognized it. The Supreme Court gave a stamp of authority to it in the last case, in the case of Abubakar Audu, that Yahya Bello inherited. So nobody is in doubt as to who owns these votes. Now, if you listen to the governor's press conference yesterday, he said this judgment was to embarrass the APC and the federal government. He didn't say to embarrass him because he knew the votes were not his own. That's why he didn't put himself there. But because the thing is shocking to him, he expected that the judgment from Ebonyi State High Court was going to influence. But the judge distinguished it that the cases are different. What you are determining in Ebonyi and what you determined in Ebonyi was not what was before him. What was before him was the right of a plaintiff, now a political party, to say, my lord, we sponsored a candidate. We nominated a candidate in line with the constitution. We sponsored him. He won election. The people found favor in our manifesto and voted for our party. And the man has now taken our victory to another place. What is our right? What is our remedy? Ubi jus ibi remedium. Once there is a right,
absolutely. Just before we go to the Honorable Commissioner, I want to come in here on anti-defection laws, because we know there is a bill at the National Assembly. I don't know if he has passed second reading on governors, presidents and their vice, not defecting, when they get into an office under a particular political party. Now, we've seen other countries like UK, Belgium, United States of America, they have anti-defection laws, even though you don't see them migrating to other parties. And they say that, these laws will help to shape democracy, especially to protect the right of votes for the electorate. Do you not think this is also very critical, especially in managing, the level of political rascality within the political section, so that this can curtail the movement of politicians?
I will support anti-defection laws. Now, when the Honorable Commissioner was speaking earlier, he mentioned issues of rights to freedom of association, so that anybody, if that right is inherent for political office holders, why then did the Constitution say that for parliamentarians specifically it was wrong, that a parliamentarian will not move? Does it mean that parliamentarians, Senate, House of Rep and House of Assembly do not have right to freedom of association?
All right.
Now let me just make another good point here now. He made reference to legal luminaries. I've read overnight a lot of positions, and the most outstanding should be the one from a man I respect so much, the Lene Silk, Michael Zokeme. I read his views, and when I noticed also that he's representing Ayade, Governor Ayade of Cross River, in a similar case, and I said, okay, that's the reason why he should hold his view, because he is now professionally bound to hold that view. But if it was the view of Mike Ozokeme SAN, without being directly interested, with due respect and utmost sense of responsibility, the Michael Zokeme Nigerians know would have held a different view.
All
but
right.
because this time now he's directly and professionally bound to hold the view he holds. So it's not like it is not that normal expressive view, because when he's normally expressive, when you read Michael Zokeme, you want to grab it and
all right,
cram it.
let's get the commissioner in now to round off this discussion. Commissioner, just your final thoughts on this matter. You've listened to the two lawyers here, so what will be your response to them before we go?
Thank you very much. I still would not want to address issues of sentiment, issues of motives. I've got no business with the law. Whatever the Constitution does not provide does not exist. And in the case of the removal or sack of the governor, there are only three conditions. And let me say that the case of Atiku and federal government, that is AG of the Federation, is pari material. So what applies to the vice president applies to the president, applies to the governor and deputy governor under the Constitution. I don't know what my learned colleagues are saying there. Again, the issue of parties' rights to choose a candidate. And I have mentioned that the council is talking about pre-election election matters. And that is not the issue for determination. The issue for determination is defection. And this defection is applicable in the case of Ebonyi, it's applicable in the case of Zamfara. There is no differentiation, there is no distinction at all. You know that. Now, having said that, we are saying that the Constitution does recognize that there is no any other thing that can remove a governor other than three things, and defection is not one of them. Now, he mentioned the issue of the APC, the person that came second in the 2019 election in Ebonyi that sued their governor. It is as of right. What is very important for a condition precedent for you to sue is local standard. And so the man has the locus under the Constitution, having come second, to even see whether he can be, giving judgment. And that he has exercised. And somebody is faulting it with sentiment. Motive is immaterial. If you like, you can go, to say a lot of things that have got nothing to do with the law.
All right.
I can tell you that not even the devil knows the intent of man. So you can't go into the voyage of knowing what is inside.
Honorable Commissioner, I'm sorry, we have to just cut in here. We are definitely running out of time. I'm sure this is an ongoing conversation. We want to say thank you to the gentlemen that have joined us this morning. Honorable Commissioner Oji Uchenna Oji has joined us via phone. He is the Commissioner on Information for Ebonyi State, and Barrister Tochukwu Ohazirike. Thank you so much for coming.
Always
it's a pleasure to have you. And Barrister Nkem